Welcome to the Legal Writing Institute's virtual conference and my presentation, The Texas Sharpshooter and Other Logical Fallacies. My name is Ken Chestek, and I'm a professor of law at the University of Wyoming College of Law. While, like you, I would have preferred to have been doing this presentation live at the biennial conference this summer, we're all dealing with an unusual situation, so I've chosen instead to prepare this narrated PowerPoint presentation that you can work through at your own pace. This PowerPoint works with several handouts that I have also included with the presentation materials. In the folder where you found this PowerPoint presentation, there should also have been 3 Word documents that go with this, and which you can use as handouts in class if you choose to teach logical fallacies using these materials. The first Word document is called Types of Logical Fallacies. It's a 6-page handout that I give to my class to identify the types of logical fallacies that one might find in legal arguments, or even in ordinary political or other discourse that students and lawyers may find themselves engaged in. It categorizes the fallacies as to why they are fallacies and gives some examples of what the fallacies look like. The second document that should have been in the folder is a contentions and analysis handout, which is a worksheet that students can work through during class, either on their own or in groups, to identify a series of potential fallacies in arguments that I have crafted dealing with a specific example, which we will work through later on in this PowerPoint presentation. This presentation is intended to be a simulated class and to show the way I teach logical fallacies using these materials and using these concepts. The third document in the folder should be an answer key, which it's similar to the contentions and analysis handout, but instead of blanks, I have proposed answers to all the 5 different arguments that I argue are fallacies, and my proposed answers as to why I think they're fallacies. You can hand out these materials, use them in any way you wish in teaching this class. This is a great class to flip because what I do is I have students read a chapter of our textbook, Your Client's Story, 2nd edition. Chapter 9 3/4 is the chapter in which we deal with logical fallacies. I have the students read that in advance, and then while I review it very quickly, I don't teach it in any kind of depth in class. What I do is I simply review the materials very quickly and then have the students work through an exercise, which I'm going to get to in a few slides, to make them think about a series of arguments and spot, if they can, the logical fallacies in each of the arguments being presented. I think this is an important class not only to help students identify fallacies in their own arguments or in arguments made by their opponents, but also just in everyday discourse, especially in today's political world. There's a lot of arguments, there's a lot of polarization going on, and people are making what sound to a lawyer's ears pretty ridiculous statements and pretty absurd arguments. A lot of them are based on fallacies, and I think any lawyer should be able to spot fallacies and identify why they're fallacies. So I think this is a very good class, very useful for any budding lawyer to have. So the way we're going to work through this, I will narrate each slide, and I will tell you when I'm done with the narration, and you can either move on to the next slide, or in some cases you might want to stop and work through the problem a little bit before you move on to the next slide. So at this point, I will end this narration, and you can move on to slide 2 at your leisure. As you know, and as you have probably already taught your students, most legal arguments take the form of a syllogism. So I think it's important for the first part of the class to very briefly, in 2 slides, review what a syllogism is, and then that sets up the exercise in which we determine how logical fallacies occur. Logical fallacies tend to be failed syllogisms, so it's important to start off by reviewing what a syllogism is. The second slide here simply uses the traditional example of a syllogism about whether or not Socrates is human, and I'm showing how IRAC is really just a syllogism, and this is a simple review. You can now move on to slide 3. This slide concludes the brief review of syllogisms by translating the standard Socrates' mortal analysis into a simple legal setting, trying to determine whether or not the defendant is guilty of speeding. You can now move on to slide 4. Slide 4 begins a very brief recap of the contents of our chapter 9 3/4, where we categorize different types of logical fallacies. We identify a group of fallacies, but we try to identify why the fallacy is a fallacy. In other words, what part of the syllogism has failed. This also is reproduced, this slide is reproduced in the handout Types of Logical Fallacies, which I do give to my students in class, mostly so they can have a handy reference to do the exercise, which will start here in a few slides. We identify 4 different groups of fallacies. One, a group in which the major premise is wrong for some reason, either false or not fully fleshed out. Another group in which the minor premise is incorrect. A third group is where both premises might be correct, but the conclusion does not follow. In other words, a minor premise does not follow from, the conclusion does not follow from the 2 premises of the syllogism. And there's a 4th category that we identify of avoidance fallacies, where for whatever reason the fallacy simply is, the legal question under consideration simply is not addressed by the argument. It misses the point altogether. And we've identified types of fallacies, and in the handout, if you want to pause here and take a look at it, we've given examples of each of the fallacies and why they are fallacies. Of course, the text in chapter 9 3/4 fleshes out a little bit more, but I hand this out as a reference for students to work through the exercise that's coming up in about 2 slides. When you've had a chance to review the handout, you can then move on to slide number 5. Slide 5 concludes the brief review of the contents of chapter 9 3/4, where we describe all of the legal fallacies that we're covering. It's simply a reminder that the fact that somebody has relied on a legal fallacy or a logical fallacy does not necessarily mean they got the wrong answer. It makes the point that even a stopped clock is right twice a day. The answer, the conclusion as presented, the argument's conclusion might actually be a good conclusion, but it doesn't necessarily follow because the reasoning process has been faulty. When you have and we call this the fallacy, and when you identify that, it just means that even though you have the right answer, you might want to rethink the legal reasoning part of it and find a better argument that is not based on a logical fallacy. And we will begin the example starting in the next slide, slide 6. At this point in the class, it's time to flip things. Rather than simply lecture about what logical fallacies are, it's time to give the students a concrete example and have them think through various arguments and see if I can spot logical fallacies in the arguments being made. The example that I tend to use relates to arguments about whether or not a convention of states called under Article 5 of the United States Constitution has plenary power or can be limited to particular purposes. I find this is a topical and timely issue because there's a number of different issues from both the left and the right that are currently working through the state legislatures for potential constitutional amendments. There's a group that's working on getting a balanced budget amendment to the Constitution. There's another group, and a group that I'm affiliated with, that's working on getting an amendment to the Constitution to overturn the Citizens United case on dark money in politics. In both cases, the theory is that Congress is not likely to make the change on its own, and the only way to get constitutional amendments proposed is to use Article 5 of the Constitution, and specifically the convention portion of that. Article 5 actually does allow for Congress to propose amendments, but it also allows for the states to, quote, call a convention for proposing amendments. And the text of Article 5 is here on the slide. So the question is, if a state were to simply say, we ask for a convention to deal with a single topic, can the convention be limited to that topic? There has never been a convention of states for the purpose of proposing amendments. All 27 of the amendments to date have been proposed first by Congress, although several of them happened after an effort in the states got very close to having the 2/3 of the state legislatures request an amendment, and before the 2/3 could be reached, Congress realized that this is a serious thing and they needed to go ahead and propose the amendment themselves, because, of course, at that point, Congress can control what the amendment says and don't want to have a convention running around proposing things that Congress might not like. So the question is, and this is, it's a very common question, and it's been raised in every effort to use the Convention of States process. The opponents of whatever the amendment happens to be raise the specter of a runaway convention, that as soon as you call a convention, the convention can do whatever it wants, and nobody can control the convention, and bad things can happen. So the legal issue that's presented is if 2/3 of the states call for a convention for a single purpose, is it legally possible for the convention to consider amendments other than on that single purpose? It seems like a simple question, but the arguments that have been made against it suggest that you cannot control a convention, and the convention can so-called run away. So what I'm going to do next, starting on the next slide, is to propose a series of arguments that I have heard in my work on the Money in Politics Amendment. I have heard all of these arguments. They're all made by serious people with serious intent. I think they're all fallacies, but they are subtle, and I think it's a good exercise for the students to try and think through whether or not these arguments are logical or not. So at this point, you can move on to slide 7, and we'll begin the list of arguments. Slides 7 and 8 list 6 different arguments that are typically made when somebody is trying to argue that a convention of states is a dangerous thing, and therefore we should never invoke that process because bad things can result from it. I put these on 2 slides only because they're too long to fit on one slide. What I do in class is quickly work through each of these 6 arguments, explain what the argument is, and then I will turn the students loose on trying to find the logical fallacies in each of these arguments. The first one is that Article 5 does not specify the rules for a convention, so it can make its own rules, and when it makes its own rules, it can basically do whatever it wants, including it's not bound by the rules given to it by the states that called for the convention. Another one is that the convention, because the convention can change the rules, it can also change the way amendments are ratified, and therefore it can make radical changes to the Constitution. This is an argument that has been advanced by serious people to me very frequently, frankly. There's an argument about the Constitutional Convention in 1787 was a runaway convention, and therefore this convention could do the same thing that the convention did in 1787. Move on now to slide 8. Slide 8 contains the other three arguments against allowing a convention of states. One argument is that a very smart law professor at Harvard has said that the convention can run away, and therefore we should be worried about a runaway convention. Another argument is that so-and-so doesn't want this amendment to the Constitution, so to prevent it from being proposed at all, let's not have a convention. And another very common argument that I hear is that the people who are proposing this amendment are fill in the blank, either too conservative, too liberal, too whatever, and therefore we can't trust them, and therefore we shouldn't allow a convention to happen. So at this point, you can take a look at the handout called Contentions and Analysis handout and move on to slide 9, where we're going to start working through that. At slide 9, I direct the students to the Contentions and Analysis handout, which starts on the first page with a repeat of the constitutional provision and the question that we're answering. And then it lists all 6 of the arguments that I showed on the previous slides with blanks that look a lot like what's shown here on slide number 9. What I direct the students to do at that point, either in groups or in pairs or individually in class, to work through each of these 6 arguments and identify the major premise on which this argument is based, the minor premise, and the conclusion. Having done that, they can look at the list of types of logical fallacies and conclude if there is a fallacy presented. In other words, is the major premise incorrect? Is the minor premise incorrect? Is the conclusion not logically following from the 2 premises? Or is it an avoidance? And then I ask them to identify which fallacy is presented by the argument, write it down, and maybe a note or 2 as to why they think it is a logical fallacy. This is a good think, pair, share kind of exercise too, if you want to have students do it individually and then talk with neighbors to argue through it. Some of these are hard to spot, and sometimes there's potential differences of opinion as to what the fallacy might be. So it's a good jumping off point to discuss what the fallacy might be. So at this point, if you care to, I suggest you might pause the PowerPoint and work through the blank exercise that does not have the answers already filled in, of course, for yourself and see how it works for you. And that way you can test whether you think it would be a good exercise for your students to engage in. When you're done working through it, we will move on to slide 10 when you're done and ready to move on to slide 10. After the students have had an opportunity to work through the worksheet and propose answers to all 6 of the arguments that I've presented about the runaway convention, it's time to get the class back together and talk about what they came up with. And like I said, many of these are maybe controversial in that there may be several possible fallacies that they could identify. So it's a great way to discuss and test the students for their comprehension of the notion of logical fallacies. I do either I hand out the sheet that's called Contentions and Analysis Answer Key, so that they can see my proposed answers. I don't try and say that these are the only correct answers, but these are proposed answers that suggest why all 6 of them may be fallacies of one sort or another. I'm just showing you on this PowerPoint presentation the first argument about how because Article 5 has no rules, it can make up its own rules, and therefore anything can happen. The fallacy presented by this, in my view, is what we call the hasty generalization. In other words, the minor premise is not complete. It is false or simply incomplete. And in this case, it's a little tricky because the point on the slide is that Article 5 is not the only possible source of rules. That's true. There's also the due process clause, which might provide some rules. There's also rules outside of the Constitution, such as the law of agency. If the state says we are calling for a convention on one topic, we are going to send delegates to this convention with explicit instructions that they can only discuss and vote on that one topic. The state is the principal, the delegates are the agents, and they can't take on any power beyond what the principal gives them, which is a way of tying back into some first-year torts concepts. So there's all kinds of ways to show why this is a logical fallacy, and you can go from there. So, as I said, I sometimes will simply hand out the answer key and work from that, or I might have a slide like this one for each of the 6 arguments, and then we can talk about them in class as to why they are or are not fallacies. And time to move on now to the final slide, slide number 11. Slide 11 is a fun add-on. If you have time at the end of class, you haven't used up the entire class discussing the first 6 arguments, it's always fun to throw it back to the class and see if they can think of fallacies that they have encountered either reading prior cases or listening to the news media or other arguments that they've heard, and simply identify an argument and identify why it's a fallacy. This is a good think, pair, share exercise as well. It can get a little political, but that's not necessarily a bad thing. But once they start thinking about fallacies, it's really easy for the student to spot them in things they've heard about, and it can be a really fun little exercise to end the class. And that is the conclusion of my presentation. As I said, all of these materials are free for you to use in class if you choose to. I also can give you a copy of this PowerPoint presentation without the narration if you wish to modify it in some way. Please send me an email. My email is on the opening slide. Just send me an email and I will be happy to send you a version of this PowerPoint without the narration. Thank you very much for listening to my presentation.